I want to bring in some more legal minds into this conversation. You can never have enough, of course. Raul Reyes, attorney who writes frequently for CNN's opinion page, and Joseph Moreno is a former prosecutor for the U.S. Department of Justice. You'll have heard David's thoughts there on this ruling. Raul, let me start with you. Your initial response to what we've just seen.
Right. I would echo his sentiments that for now, this is a win for the Trump administration. Whatever you think about the ruling, it is basically what they wanted. And again, it's so important to emphasize this is not a ruling on the merits of birthright citizenship. The court was really just looking at whether or not federal courts, the lower courts in the U.S., can issue these nationwide universal injunctions. The relief that now people going forward will have is to bring litigation on their own. And we think of that as potentially hundreds, thousands of cases. However, remember, we are talking about, when we're talking about undocumented people, their children, people in the U.S. temporarily, it will be extraordinarily difficult for them to mount cases. States cannot bring class actions on behalf of such people. So in my view, it will be a tremendous hardship for them to seek relief from the courts going forward. I think the average American has difficulty in many cases finding a lawyer to litigate their case or when they come into a legal situation. The idea that undocumented people and their children can now seek relief through the federal court system and beyond, practically speaking, is really a hard concept to wrap my mind around. Mm-hmm. And even though what's interesting about this case, it is involving immigration, but at a broader level, it's about presidential power. It's about redefining, at least temporarily, who is an American, and it's about the role of the judiciary as a check on executive authority.
Yes. Joseph, as a former prosecutor for the U.S. Department of Justice, how do you assess this ruling through that lens?
Well, I think it's a showing of how important it is when you get Supreme Court confirmations of a certain ideology, right? And this is exactly the 6-3 majority when you look at conservatives versus progressives on the court. And so it shows that those nominations that are so fought bitterly are really important when it comes time to actually rule on cases. And I agree with, my colleagues here. I mean, this is a big win for the Trump administration. I think it's frustrating that the 14th Amendment birthright citizenship issue was not decided on the merits. Hard to believe since 1868. It's never precisely been ruled on, but not surprising. This is actually very consistent with the court, where they want to keep their decisions narrow. But as far as effectively ending these nationwide injunctions, short of certifying as a class action, which is difficult, it effectively puts to rest that process of being able to go to any district judge, all 680 of them across 94 districts, and getting what you want.
David, the opinion says this, and I think everybody's just getting an opportunity to just read in here. Mm-hmm. The court grants the government's applications for a partial stay of the injunctions entered below, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff. My team is reading this, as I am, as restricting the lower courts, correct? I mean, are we right in saying that? And as you read through more of this, what else is jumping out at you?
Well, I think you're correct to read. And just to remind people here is that, as one of my professors used to say, cases are all about two parties, party A versus party B fighting about something here. And what the court is saying here, Supreme Court appears to be saying here, is that any injunctions should only apply to the particular parties in the case, which means in this case here, as I'm reading, unless my colleagues want to say something different here, the court is saying that the injunction that was issued in this particular case here only applies to the parties here, but not applies to anybody else who's, let's say, similarly situated, who is also seeking relief from deportation. So this is also a at the same time, the expansion of executive power, it is a significant shrinkage, I would argue, of judicial power in the United States. And this is going to have big implications, not just for Trump, but for the Trump administration, but for U.S. politics going forward, because it has been a practice to be able to find that one district court in the country or one judge to be able to get a ruling that applies across the country. But here, this is going to really put in a situation where not just with immigration, but with a whole bunch of issues now where I think the court hasn't thought through, well, the implications of what this means in terms of how much more of a burden this is going to place, not just on plaintiffs, but on judges across the United States in courts. There's going to be a lot more litigation in this area.
I do think for our viewers' sake, we, once again, as ever with these Scottish rulings, need to step back and just remind ourselves, and I'll start with you, Raoul, what does this actually mean in terms of birthright citizenship? That's the big issue here, even if it's not the specific legal issue, correct? This ruling is about process and sort of logistics, but behind that is a huge contentious issue in the United States at this point.
Exactly. It's not so much a contentious issue in the United States because birthright citizenship it's in the Constitution. It's been settled law for 125 years. However, in this case, although it turned on legal and some procedural issues, it's impossible to ignore the practical impact. What this potentially means going forward, that people around the country, as I'm reading through this very thick opinion, it potentially means that some people will be subjected to President Trump's executive order, and other people, depending on what states they were in or whether they were part of the original plaintiff class, will not. And think about this: in the United States, every year there are something like 225,000 children born on American soil to undocumented parents or people here temporarily. That is the group of people writ large that could be impacted by this decision in the moment, although the case won't be decided maybe for a few years. In the meantime, what will happen to these children born on U.S. soil in the meantime? Will their citizenship be questioned from state to state? Will they be U.S. citizen in one state, and if they move, not in another? And although that seems like a radical idea, in my opinion, it is the idea that your rights could change from state to state. We have seen this before with the Dobbs decisions, where American women now, their right to reproductive care, it does change from state to state. Only now we are talking about something as fundamental as citizenship here.
Joseph, where does this leave the executive order?
Well, it's going to make its way through the courts now on the merits. And I think I'll take issue with one thing that was said. I think the 14th Amendment language has largely been read a certain way, but the courts have never truly ruled on its precise language, which is someone who's born in the United States and subject to the jurisdiction thereof. And there's an argument to say that if your parents are here temporarily and they're citizens of another country, that language carves out that birthright citizenship that's been taken for granted so long. Now, I don't know how that'll go. It'll probably go with the way the amendment has been read all these 150 years. But that issue has yet to be determined, which is really fascinating. And so it will work its way up through the courts. And I think ultimately in a few years, the court will have to grapple with what it did not decide on today, which is what precisely does that language in the 14th Amendment confer in terms of citizenship? And should we deviate from the way it has been read these past 150 years? And then one more thing, retroactively, what does happen to the people in the meanwhile, which is a tough question.
David, I've got another line from the majority ruling here, so let's get that for our viewers. You will have seen this. When a court concludes that the executive branch has acted unlawfully, the answer is not for the courts to exceed its power too. That's Justice Amy Coney Barrett writing. She went on, quote, "The court today puts an end to the increasingly common practice of federal courts issuing universal injunctions." Does this ruling restricting lower courts then from issuing nationwide decisions, does that mean that every single court across the country will be hit with these suits about alleged unconstitutional issues? I mean, that is going to clog the court system, surely, if that's the case.
That's certainly the case here. I mean, what's interesting about Amy Coney Barrett's line is I can almost read that juxtaposed to perhaps the most famous line in U.S. Supreme Court history from Marbury versus Madison that says it's clearly the province of the court to declare what is constitutional. And I say that because under Marbury, which is considered the most foundational case in American law, it does seem to assert broad authority for the courts to be able to check presidential power when it's exceeded its authority. Here, this is almost as if the court is trying to avoid a conflict with the president of the United States, as opposed to saying that it's our job to make decisions about constitutionality. And it's also in the process here similarly limiting lower courts, creating, as I pointed out here, this potential for significantly more litigation. And in the process, I think what the court is hoping is that over the next several years, as these cases work through the court, that maybe at some point Trump is no longer president, maybe the executive order is rescinded. I think it's trying to avoid a direct conflict with the president, but in the process, as my colleagues are saying here also, it's placing potentially hundreds of thousands of people in limbo regarding their status. And this is really backing away in terms of how the court decided to act today, backing away from, again, what I think is the most foundational principle of what the federal courts are supposed to be about, declaring the constitutionality of laws.
Very significant decision by the Supreme Court, ruling just in the past half hour. Raul, Justice Sotomayor dissents, writing, and I quote, "The gamemanship in this request is apparent, and the government makes no attempt to hide it. Yet shamefully, this court plays along." What does she mean? And are dissents normally that strongly worded?
Yeah. Well, increasingly and lately, I would say yes. But I think I get what she means. These cases, when these questions were in the lower courts, 3 times in Massachusetts, in Maryland, in the state of Washington, the Trump administration lost in all of those cases. They bypassed the Court of Appeals. It's in a different court, in a different Supreme Court makeup. It's not even clear that our highest court would have even accepted this case. But the Trump administration, I think their sense, correctly as it turned out, is that this court, the conservative majority, is generally favorable to their view of expanding presidential power. So in my view, what Sotomayor is saying is that the administration, in a sense, is taking advantage of what they see as a favorable climate at the makeup of the court right now, and has moved quickly because we've had nationwide universal injunctions used in the last 5 different administrations with a different court makeup when federal courts have challenged, for example, President Biden or President Obama's executive orders. Then the Supreme Court did allow these executive orders to go ahead. That stopped things like the expansion of DACA and some provisions of Obamacare. But now the court, in a sense, is reversing in this, and it's hard to see it on outside of ideological lines. They are saying that national injunctions are not cool when they're done by more liberal courts around the country, but they're all right if they're coming. That they're not all right when they're coming from the progressive judges. And I can't emphasize enough that what we are potentially creating here is this self-perpetuating underclass of stateless children. They will not be American citizens in some places. They have no connection to their countries of origins. And going forward, it's just going to be a mess to sort out what their citizenship will be, where they belong and whether or not they indeed are Americans.
Joseph, your final thoughts, if you will, and to Raul's point there, how many kids are we actually talking about here?
Thousands. It's an issue that does need to be resolved on the merits. So I think this is frustrating for those of us that would have liked to see that. I understand the court's predisposition to take literal readings of things, but they do also have to take the practical realities. And I do think that those that are in between, kind of stuck in between, I think are going to be in a really tough spot. Ultimately, Congress has to figure this out also about the national injunction issue. Remember, other than the Supreme Court, which is created by the Constitution, all the district courts are created by Congress. And Congress can fix this ultimately by saying, yes, there is a need for national injunctions in certain circumstances. Here's how to do it. Maybe it's a panel. Maybe they all go through the D.C. Circuit. Maybe they get fast-tracked in the Supreme Court. But ultimately, our lawmakers really need to step in here and figure this out.
Look, we couldn't have done this without you guys. A big decision by the Supreme Court today, impactful and important that we get really good analysis on this for our viewers around the world. Thank you.